Good afternoon and welcome to this special called meeting of the Cobb County Board of Ethics. My name is Carlos Rodriguez. I'm the chairman of this distinguished board. I do want to note at the outset that we have a quorum, and so this board can take official action as authorized under the code. And before we move to our counsel, Lynn Rainey, I do want to ask my fellow board members to introduce themselves and introduce the appointing body. And so for myself, again, Carlos Rodriguez, I was appointed by the probate judge of Cobb County, Judge Kelly Wolk.
I guess I'm first. My name is Cynthia Smith, and I was appointed by Mr. Craig Owens, Sheriff of Cobb County.
My name is Janet Savage, appointed by Cobb County Tax Commissioner Carla Jackson.
My name is Ron Yonker, and I was appointed by the State Court Clerk, Robin Bishop.
And I'm Leilani Plendle, appointed by the Board of County Commissioners.
I'm Richard Wheeler. I was appointed by Chief Magistrate Judge Brendan Murphy.
Thank you, members of the board. Again, we have called this special meeting in response to a formal complaint that's been filed against Commissioner Jerica Richardson by a member of the community, resident of Cobb County, Ms. Deborah Fisher. Before we move on with the proceedings of the day, I would ask the board's counsel, Lynn Rainey, to provide an introduction to the pleadings and give a consideration by the for the process for the Board of Ethics to follow.
Thank you, Mr. Chair, members of the board, and those who have assembled here and elsewhere. The purpose of this public meeting of the Cobb County Board of Ethics, which is being broadcast on TV 23, is to conduct an investigatory review to consider a complaint filed by Deborah J. Fisher against Cobb County Commissioner Jerica Richardson. The Ethics Board is required to proceed strictly in accordance with the Cobb County Code of Ethics. We will follow the rules set out in the code and will take such action as is authorized and required by that code. The board will be transparent, fair, and impartial to each of the parties. The next step under the code when a complaint and a reply is filed is to conduct an investigatory review. We must meet in public to discuss the matter. The board members have not previously met and discussed the matter. The board members have received copies of everything the parties have filed and had the opportunity to individually review in the privacy of their own homes and offices. Today will be the first occasion that the members will have to discuss the matter. Nothing has been decided. The sole purpose of an investigatory review is to determine whether specific substantiated evidence from a credible source exists to support a reasonable belief that there has been a violation of the Cobb County Code of Ethics. That verbiage is directly from the code. Ms. Fisher and Commissioner Richardson, this is your opportunity to tell the Board of Ethics in person why they should either proceed or not proceed with this complaint. The Ethics Board will not be hearing your testimony or testimony from your witnesses during this investigatory review or considering affidavits, documents, or materials not already filed with the clerk of the County Commission and previously provided to the Ethics Board. The board will only be considering the filed written complaint of Ms. Fisher, the written reply of Commissioner Richardson through her attorney, and filed affidavits, documents, and materials. You are invited to state to the board in this meeting how the materials already filed support or do not support a reasonable belief that there has been a violation of the Code of Ethics. Please understand, Mr. Rodriguez, the chairman of the board, has the responsibility to ensure this meeting proceeds in an orderly, civil, and respectful manner within the bounds of the Code of Ethics, so he must retain his discretion to limit or terminate your presentation should it stray from matters subject to our jurisdiction. The board will hear first from Ms. Fisher when she is through speaking, and I believe the board may have some questions of her or the opportunity to do that when Ms. Fisher, when you're done. It will then hear from Mr. Odell, who is Commissioner Richardson's attorney here. The board will then discuss the matter here in public and vote. The board does not recess into a jury room. It's all done here in front of everybody. If a majority of the board determines that specific substantiated evidence from a credible source exists to support a reasonable belief that there's been a violation of the Code of Ethics, a public formal hearing will be set at a later date at which both parties will be allowed to testify under oath, present the sworn testimony of witnesses, and present evidence. If the board, after such a formal hearing, determines clear and convincing evidence shows any violation of the Code of Ethics, it may issue a censure or reprimand to the commissioner. It may also consider Ms. Fisher's request for injunctive relief. However, if a majority of the board determines today that no specific substantiated evidence from a credible source exists to support a reasonable belief that there's been a violation of the Code of Ethics, it will dismiss the complaint. Mr. Chairman, I yield the floor to you to preside over the investigatory review.
Thank you, Mr. Rainey. As our counsel has stated, we're going to stay within the four corners of the complaint, the documents that have been submitted to the board, and the same thing with the response. I do want to invite members of the board to ask of the parties any questions after they have made their presentation. So, for example, if members of the board have any questions of Ms. Fisher following her explanation of the complaint, at that time, we'll do so, okay? We'll reserve discussion until counsel for Commissioner Richardson has responded, given his presentation. Again, then we can ask of any questions that you may have of Commissioner Richardson's counsel. At that time, we can go into our discussion phase and then entertain any motions that we may have. Okay? So I'd like to invite Ms. Fisher to the podium. To the extent that you want to present the board with or show us any documents that you've already submitted to us, you've got a document projector there to your left. Okay? Podium's yours.
Actually, excuse me one minute.
Good afternoon, Chairman and board members of the Ethics Board. If you will allow, I will, before presenting my case, state for the record that I'm filing this complaint on behalf of myself and not in the capacity or affiliation with any organization. I will begin with my statement directly taken from the Commissioner's Guide by the Association of County Commissioners of Georgia. Their statement is in direct reflection of the codes mentioned in my affidavit and is the basis of my complaint. As a conflict of interest does exist, as does the perception of a conflict of interest. I will quote from that guide. Quote, county commissioners are restricted by law not to undertake specific actions that may impact the county or negatively affect the public welfare, including a conflict of interest or a perception of a conflict of interest by the public, unquote. For clarity and brevity, I will read only portions of the specific codes included in my complaint. Complaint Code Number 1, Cobb County Code Section 2-46 on impartiality. Officers may not take part in any personal, business, or professional activity, or receive or retain any direct or indirect financial interest that places them in a position of conflict between their private interest and public interest that relates to their responsibilities and duties as officers. B, officers may not use their positions to induce, coerce, or influence a person or employee, including subordinates, in any way that would provide any benefit, financial or otherwise, to themselves or to other individuals, or to any for-profit organization of which they're a member. Notwithstanding the above, the officer may not vote upon any matter involving any organization of which the officer is a member, except boards or authorities on which the officer serves by virtue holding elected officials or by appointment of the Board of Commissioners or the governor or agency of the state. 2-46C, no officer shall use public office for private gain, give preferential treatment to any person. D, officers shall not allow any person to improperly influence them or unduly enjoy their favor in the performance of their official acts and duties, unquote. Moving to Section 2-47, abstention to avoid conflicts of interest. A, it shall be a violation of this code of ethics for any officer to participate directly or indirectly through decision, approval, disapproval, recommendation, or in any manner upon the following, which is deemed to be a conflict of interest. D2, any matter in which the officer has a financial interest, a fiduciary interest, a corporate interest, or an employment interest. 3, any matter in which the requirement of impartiality as contained in Section 2-46 would be violated. B, except as otherwise provided by law, no officer shall, in such capacity, participate in discussion, debate, deliberation, or vote, or otherwise take part in the decision-making process on any item before the officer in which the officer has a conflict of interest as defined above, unquote. It is my contention that Commissioner Richardson, the founder and sole registered director for which it stands, herein, after shall be referred to as organization, has violated multiple Cobb County ethics codes by creating her 501c4 nonprofit organization that is being used to promote and defend the Home Rule Resolution. This organization creates a conflict of interest, a direct and indirect financial benefit. Its existence gives the appearance of impropriety, and it is evident that Commissioner Richardson is using her position as an elected official for private gain by selling favors, merchandise, and giving preferential treatment by selling access and favor to the organization's members. With that, I present the individual complaints of the case as prescribed in Conflict 1, 2-46, A, B, C, and D. Ms. Richardson's organization and website gives the appearance of impropriety and clearly demonstrates a conflict of interest between her private interests, being her organization, and her public interest as commissioner. The organization's website, as cited in my affidavit, clearly substantiates that Commissioner Richardson has both a direct and indirect financial interest. My claim includes the following summaries of violations of the Ethics Code. They are as follows. 1, using her elected office for private gain by collecting money through donations, memberships, and by selling home rule merchandise on her website. Membership perks. They grant access to elected officials. Membership perks offer voting power for legislative issues, which gives the impression, the clear impression, of selling influence. 4, Commissioner Richardson's organization features her public videos, pictures, interviews, and press conferences on her organization's website, all to promote the home rule maps and resolution. This places her in a position of conflict between her private and public interests that directly relate to her responsibilities and duties as a commissioner. The membership perks give the impression that members of her organization are given the opportunity to enjoy favor the commissioner under her official duty of as an elected official. This concludes complaint number 1. Conflict number 2, 2-47, A, subsections 2 and 3, as well as 247, B, and C. The following violations support my request for injunctive relief in having the courts void Commissioner Richardson's 2 votes cast for approval of the Home Rule resolution. Commissioner Richardson has committed the following violations. 1, she has failed to report her conflict of interest due to her financial benefit and fiduciary interest, and also failed to discuss her corporate interest, in which the Secretary of State business filing, which was in the affidavit, reflects the registration date is within days of the first discussion on the first possible discussion on home rule held by the BOC. The filing identifies Commissioner Richardson as the registered agent and the sole director of this corporation. In addition, her organization website defines her as founder of the organizations, with 2 non-registered directors of the corporation posted on the website. Commissioner Richardson refused to recuse herself from 2 separate votes taken on the Home Rule resolution approval, even after being asked to recuse herself due to a conflict of interest. Number 3, she did not remove herself from discussions pertaining to the Home Rule resolution. 4, she has remained on the dais at all times during all discussions concerning the Home Rule resolution. 5, she has not recused herself from any executive session where Home Rule litigation would have or could have been discussed. Number 6, Commissioner Richardson, by refusing to recuse herself, has put herself in a position in which she cannot remain impartial as required by law. Number 7, the Home Rule resolution benefits the commissioner personally and financially by allowing her to keep her elected seat, her income derived from holding that seat, her county benefits, and her current residence. This concludes the conflict number 2. For clarity on the Cobb ethics policies that Commissioner Richardson failed to uphold, I read you portions from the Cobb County Code, Section 2-42, Declaration of Policy. Quote, in furtherance of its responsibility to protect integrity of government and administration of the county, and recognizing that its system of representative government is dependent upon the people maintaining the highest trust in public officials, the Board of Commissioners finds and declares that the people have the right to be assured that the impartiality and independent judgment of public officials will be maintained. Public interest requires that the county protect against improper influence of the appearance of improper influence by establishing appropriate ethical standards with respect to the conduct of public officials. Officers, by their conduct, should avoid the appearance of impropriety. In summary, Commissioner Richardson has violated her oath and her duty to remain impartial, as well as fiduciary responsibilities. She has benefited financially by interests that she herself created when she founded her organization that conflict with her professional capacity. Lastly, Commissioner Richardson has not maintained impartiality and independent judgment. It is my belief that my complaint before you have met the standards as set forth in Cobb County Code 2-78, granting me an official hearing. At this time, I ask the board to determine that I have presented specific, substantiated evidence that I am a credible source who has presented the evidence that demonstrates a reasonable belief there have been multiple violations committed by Commissioner Richardson. In addition, I ask this body to accept my ethics complaint as a valid claim and ask you for a favorable vote to grant me a full evidentiary hearing. And with that, I would like to show you a couple of slides from the presentation that was attached to my affidavit that were taken directly from, for which it stands, Commissioner Richardson's website. I'm trying to get this staple out of here if you're wondering what I'm fumbling around with. I'm guessing you don't want a staple. Okay. You can just flip through those. Thank you. That's it. That concludes my presentation.
Okay. Thank you, Ms. Fisher. Do any members of the board have any questions for Ms. Fisher? Okay. So, Ms. Fisher, I do want to ask you a couple of things. I think you had articulated what you believed to be the private gain that Commissioner Richardson allegedly received by creating this nonprofit organization, which is that she essentially gets to remain in office as a county commissioner, get paid, receive the financial benefits that come with, the lawful financial benefits that come with being a duly elected county commissioner. Is that
That is correct.
Okay. So you're not alleging that she received any financial benefit from being the registered agent?
No, that is directly and indirectly. She definitely has benefited from collecting money from the organization in which she is the registered agent and as well as the founder and director listed in the business application.
Okay. Do you think that a county commissioner that is attempting to represent their constituents and advocate for certain issues that they believe that their constituents want in order to remain the elected county commissioner is an improper act in order to stay in office and receive a financial benefit?
Commissioner Richardson's ability to stay in office is directly related to Cobb County Code. It is not denied by state statute. I believe that Commissioner Richardson has done a great job in her term so far representing her constituents. However, I believe that this organization was created. I don't believe the timing was coincidental. It was requested several days after Governor Kemp signed the legislation. It also is, if you will, I believe there's a link to the website. If you will go to our website, they direct many, many different things back to promoting home rule, including membership, including all of the merchandise, which the vast majority is created for home rule / local control. I believe it is not the duty of any commissioner to benefit financially off of a situation before the Board of Commissioners in which she is directly affected by. I believe it presents, if not a total conflict of interest, it certainly presents the appearance of impropriety. And I don't believe I stand alone on that opinion. And as if I understand the code correctly, the bar is set for both a conflict and the appearance. It's repeated throughout the Code of Ethics in the Cobb County Code. The appearance of impartiality, the appearance of a conflict of interest. And I believe that's the bar that this board needs to use to determine if there's enough evidence to move this forward, which in my humble or not so humble opinion, there is.
So I have a question.
Yes,
just
sir.
want to make sure I understand. You believe or you know that, do you believe or do you know that Ms. Richardson received funds from the nonprofit as a personal matter? Received personal funds?
I do not know because Ms. Richardson has filed no paperwork with either the IRS or with the Secretary of State on financial disclosures for her 501c4. I also do not know, because she is yet to, or at least maybe it's the IRS behind the times, which wouldn't surprise anyone in this room, but they have no certificate on file for the 501c4. I have no way of proving that she has or has not.
Thank you.
I have a question.
Yes, ma'am.
How are the allegations that you make against the commissioner any different from the way in which any politician would otherwise raise funds or raise awareness for things that are related to their constituencies?
I do not believe they are allowed to. If you read the code, they are not allowed to raise funds for their constituency from a private corporation. If you read the code, would you like me to reread that code?
No, I would not.
Okay, thank you.
Ms. Fisher,
Yes, sir.
the purpose of the nonprofit organization, how is the purpose of the nonprofit organization adverse to Cobb County insofar as it places a conflict of interest between the purpose of the organization and the commissioner's duty and responsibility to represent her district in the county?
The conflict is created, as claimed in my affidavit and as presented today. She did not recuse herself from the vote. She receives direct benefits from promoting the Home Rule resolution. She is capitalizing on that direct conflict by selling merchandise that includes all kinds of clothing, cups, buttons, stickers, and if you look at her website, it states it is the #1 issue. It asks people to join, to get involved, to advocate for home rule, which I do not deny the commissioner that ability, but not when it is directly related. If you click that link, it takes them right to the membership button and the donate button.
So your position is that she could advocate for the home rule as long as the home rule is not some sort of issue or controversy that pertains to her?
Ask me that again. I'm not sure I understand your question.
I thought you said that you don't have a problem with her advocating for issues pertaining to the home rule.
Absolutely not in her capacity as a commissioner. She does a great job holding her huddles on Saturday mornings. She does a great job in communicating with her constituents. But what she can't do is promote this through her organization and profit from it. And I realize it's a nonprofit, so they do not take on a profit. It should be used for the purpose of the organization. However, that is what I would consider an indirect financial benefit, because she is raising money to independently, from her position as Commissioner of District 2, which I used to be. I do not recognize that I am still in District 2. However, I believe it is totally improper to link the majority of the information on that website back to money.
All right, so back to my original question, how is it that the purpose of the organization conflicts adversely with her public duty and responsibility as a county commissioner?
If you don't see this a conflict of interest and all the different codes that I just read to you, I don't know that I have an answer for you. I believe she is personally gaining, because if not for the resolution, according to the attorney for Cobb County, she would not be allowed to continue after January 1st, 2022. However, that in itself is a little confusing, considering the legislation passed and state law allows her to remain in her position as commissioner for the redistricted District 2. I do not believe any of this is happenstance. The timing, the vast majority of the website promoting the home rule, if it weren't for the home rule resolution, she would not be in office.
Any other questions from members of the board?
I have a question. We keep talking about finance. Ms. Fisher, is there any proof of that Ms. Richardson is financially benefiting off the nonprofit?
As I've stated, she is yet to file the required paperwork with either the Secretary of State or the IRS. If she has filed it, there's no proof on either website.
Okay, unless there are any additional questions of Ms. Fisher, thank you so much for your presentation.
Thank you very much for your time and your consideration.
Yes, ma'am, thank you. And I will call on Mr. Odell on behalf of Commissioner Richardson. Please, sir.
Proceed. Good afternoon. My name is Justin Odell from the law firm of Odell, O'Neill, Hungerford, and Blanchard. I am here representing Commissioner Jerica Richardson for purposes of responding to the complaint, ethics complaint as amended, which was filed against her, and for purposes, moreover, of rectifying and responding to what has been a long-standing, I believe, narrative and attempt to unseat Commissioner Richardson through a variety of means. As set forth in her affidavit, you have learned and read from evidence that we have submitted that Commissioner Richardson was duly elected in November of 2020 by the will of the people speaking through the majority of the voting citizens of District 2, making up a historic election result for the Cobb County Board of Commissioners. She became the first African-American individual and first female to represent District 2, became a portion of the first Board of Commissioners to be made up of a majority African-American commission as well as a majority female commission. The election was, in that sense, a historic one. And since that time, there has and continues to be, we believe, an effort to undermine the results of that election through legislative and other means. Now, we have to pause here for purposes of my response and for purposes of your analysis, because you are charged with making a determination of whether or not there has been specific, substantiated, credible information to expose or to evidence violation of the rules of ethics cited 2-46 and 2-47. Our position being there is nothing specific, nor substantiated, nor credible. That election resulted in a vote and determination by the Georgia General Assembly to redraw district maps. Now, what led to the redrawing of the district maps is relevant for your analysis here. Commissioner Richardson, having been duly elected, did what everyone dreams of doing. That is, she bought her first home. She bought that home. She was residing when she was elected in an area that is largely comprised of apartments. She then bought her first home in June of 2021, located well within the heart of District 2. Her new residence was not materially any further from any boundary of District 2 than where the apartment was that she had been living. It merely was a chance to live the American dream and gain home ownership. However, immediately in reaction to the November 2020 elections, the county has experienced and seen an entire legislative process designed to either create cities, carve up Cobb County, or redraw Cobb County in a way that individuals who don't feel like they ought to be represented by Commissioner Richardson can have their wish despite the results of their election. As set forth in her affidavit, the way the process of reapportionment is supposed to unfold is through the local delegation. So at the time that she moved within her district from one area of District 2, purchasing her first home in another area of District 2, Commissioner Richardson had no reason to think, doubt, or believe that she would be allowed to continue representing District 2 as the people chose her to do. She purchased her home, settled in, and began about her work. Unfortunately, as set forth in her affidavit and as set forth in the materials submitted, the Cobb County local delegation did not follow the traditional process, or was not allowed to follow the traditional process for drawing a map. Instead, the process which has ruled Georgia for 100 years was bypassed. And instead of the local delegation introducing a map, it was introduced by means of a general bill passing the General Assembly and creating a new map which essentially flips District 2 completely over like a pancake, rendering it virtually impossible for Commissioner Richardson to have a place to live. Understand, if she were to move, to relocate, she would have to live both in old District 2, she would have had to move from old District 2, because that map didn't take effect till January 1st, and be within new District 2. That's the puzzle that was created for her. That area, I would love to live there because it centers around the Battery, Truist Park, and the Vinings area, one of the most expensive and affluent areas of the county, is where she would have been the only place that she would have been forced to relocate. Obviously, being unable to do that, she stayed where she was, and she began to go about the work of the will of the people who elected her. Now, once again here, we must pause, and as we get to the allegations, I'll address this in further detail. There is a myth or mythology that gets promulgated in these sorts of things that somehow an elected board of commissioners and individual commissioners within that board are to refrain from advocacy. They're not. In fact, it's expected of them in our system. They have a fundamental constitutional protected right to engage in advocacy and political speech aligned with the will, the majority of those who elected them. It's what we expect them to do. And they take positions and advocate for a variety of issues and educate their constituents on those issues. And that's permissible and allowable and, candidly, expected. So as the process unfolded that I just described, making it apparent that there was an effort underway to violate local control, to violate the will of the Cobb County people, Commissioner Richardson set about educating and advocating against it. And she followed the constructs and constraints that now exist in our system following the decision in Citizens United, the United States Supreme Court decision. She followed the very constructs and constraints that exist through the 501c3 or 501c processes to do that. In other words, she did exactly what the law says she's supposed to do in establishing an organization built upon advocacy and education of her constituents. Completely transparent, completely above board, and completely within the confines of our system. And she went about her work. Simultaneously, the Board of Commissioners went about its work in passing the Home Rule law. Now, despite what a lot of people might say, and a lot of people have said, the Home Rule legislation and the acts of the General Assembly are truly unprecedented. Everybody wants to come in and have an opinion on it, but the reality is nobody knows for sure what the effect of that Home Rule decision and what the effect of that General Assembly action is ultimately going to be. But I will submit to you, and I say this with due respect to your body, what is attempted here is an end run around those legal proceedings and should be dismissed as such. They are asking you essentially to declare her actions void as a means to bypass what they've been unable to do through the courts by having you void those actions so as to undo the map that was passed in Home Rule. That's what this is. That's what she's asking you to do, to make an end run around the judicial process and the cases that will play out there, and effectively declare that so long as Commissioner Richardson can't vote and those votes were taken are void, therefore the existing map that's in place as passed by Cobb County would not be of any further effect, giving them the victory that they so desperately seek to achieve. That's what this is really about. Now, we are in uncharted waters. I've submitted in the proceedings to you, in the materials that I submitted to you, that the legal experts advised the General Assembly at the time they were making the end run around the process that they're supposed to follow, that you are in uncharted waters. This is unprecedented, and they don't know if you can really do this. We don't know if you can unseat an existing commissioner by redrawing a map and not following the process that you're supposed to follow. So we're not sure what the effect of all this is. So if they're not sure, I'll submit to you that it's a matter properly before the courts of our state to decide. And I submit to you that they will. And that's how things in this country should unfold and how these decisions should be made. And that's what brings us to the complaint.
Mr. O'Dell, I'm sorry, excuse me. You're doing an awesome job of explaining kind of the background, what led us up here. As far as the Home Rule, can you talk to us about the allegations in the complaint and the Code of Ethics?
Yep, that's where I just was headed to. That's what I said, which brings us to the complaint that was filed. The complaint that was filed cites two code sections, two operative sections, 2-46 and 2-47. So the backdrop I gave you is essential to understanding what it is Commissioner Richardson is doing and exercising her right to do as an elected official. The two code sections that are cited address two things. One, impartiality, and two, abstention due to conflicts of interest. Now, I'm traveling under the amended complaint. I think the initial complaint attempted to say merely by just merely voting that somehow Commissioner Richardson had violated her oath of office. I charted out in my responsive letter that I failed to see any citation or any enumeration as to how that would have occurred. And I didn't hear that being re-enumerated today, so I'll sort of leave that lie. And where that takes us then is whether under 2-46 or 2-47 there is any violation as to what would have occurred as set forth in our response. First, dealing with 2-46, which is impartiality. 2-46 contains various subparts. Part A says that an officer must not take part in business, professional activity, or receive or retain any direct or indirect financial interest which places them in a position of conflict between private interest and public interest insofar as it relates to their duties and responsibilities as an official. Subpart B of impartiality essentially says the similar language only related to the inducement, coercion, or influence of another person or subordinate that would in any way benefit them. There is a unique caveat here, as pointed out in my response, and that is that under subpart B, the restriction in subpart B states that the conflict would provide any benefit, financial or otherwise, to themselves or other individuals or to any for-profit organization. Now, your operative definitions under subpart B state that a for-profit organization is different than the definition of a business or business entity. And when we construe this code section, it must be construed strictly. So we have to believe that your ethics code says for-profit for a reason, as opposed to saying business entity. Because a business entity would include an entity whether or not for profit, but a for-profit organization does not. So the not-for-profit 501c, and I'll tell you why it doesn't include that here in just a minute, 501c is not included within the definition of subpart B. So where that leaves you essentially with is subpart C, which says no officer shall use public office for private gain. There is no assertion containing specific, substantiated, or credible evidence that Commissioner Richardson is using her public office, that she is doing anything through her public office for private gain. What she is doing, advocating on behalf of a 501c4 organization, is not her public office for private gain. Be clear about that. Why is that distinction drawn? Well, it's a logical one. All of your political institutions and structures are similarly such. If you were to open the website of pick your political party right now, including Ms. Fisher's, you would see what? The ability to buy merchandise. You would see the ability to comment or follow on matters of county business. You would see photos and you would see speeches given by public figures, elected representatives, to those bodies, talking about the various issues that those political parties may or may not be addressing or involved in. Those political parties raise money. Those elected officials help them raise money. Those elected officials then benefit by what? Those parties giving them money to help keep them in office. That's our system. And it might not be perfect, but that's what it is, and that's how it operates. And to attempt to suggest that a commissioner would not be allowed to be engaged in advocacy or political activity simply because the outcome of the advocacy or political activity would help them remain in office would undermine the entirety of the entire political structure that we have in this country. So it's not the outcome that your ethics code is targeting specific examples wherein a commissioner has a pecuniary interest in the outcome directly of a vote taken by the Board of Commissioners. A property interest, a business interest, a financial stake in a gain. In other words, I'm going to win or lose dollars depending on the outcome of this vote. Trust me, Commissioner Richardson would love more than not to have to help advocate and educate the public about home rule. She would love for it all to just go away, for the General Assembly to do what it is supposed to have done, follow the rules that govern this state forever and ever, and pass a map, just like they always have and just like they should have done, and none of this would have been necessary. But she has a right as a commissioner to advocate, argue, and fight for the people that elected her and what she perceives to be the will of those people. Now, if a will of the majority of the people in her district disagree with what she's fighting for and what she's advocating for, there's an outcome that can occur, and it occurs every 4 years. We have a referendum on whether you agree or disagree on what the existing advocacy of a commissioner is, and that's how the process resolves itself. So I'll submit to you as to 2.46, which is your impartiality code, it does not apply to the allegations that are set forth related to Commissioner Richardson. Next is the abstention, this is basically a bootstrap of the former complaint, because the second complaint says, to the extent she has a conflict of interest, which I just argued, she therefore should have abstained from a vote, particularly the 2 votes to pass the home rule map. And there's no allegation as to how. If you read abstention, it simply says that it's a violation for the officer to participate in a decision upon which it would be a conflict of interest. And what they're basically saying is, because the home rule map passed by the county keeps her in office, she has an interest in passing that map. Well, so do all of them. They all have an interest. Whenever they pass a map, they all held that interest when the vote was taken. Everybody held an interest whenever they drew a map and submitted it to the General Assembly, and that what should have been introduced through local legislation. All of them have an interest in that outcome. That interest in and of itself cannot be the interest that you're talking about. The interest referenced here, it says, is a financial one, and an interest that affects their ability to deliberate and otherwise vote and take part in the discussion. And that didn't occur here. And so to abstain from that vote, I'll submit to you, would not have been proper. So what we drill down to in conclusion, is, in review of the complaint, do you have specific, in Mr. Haney's Mr. Rainey's opening remarks, he must have said it 4 or 5 times, specific, substantiated, and credible evidence. So when you consider the basis for what's been brought, the relief being sought, consider the relief being sought as what is motivating this complaint. They're asking you to essentially void 2 votes of the Cobb County Board of Commissioners to undo a map. So you consider credibility in light of the relief sought. This is what this complaint is designed to do. That's what they're targeting. That's what they're asking you to do. They're asking you to consider that. So are they specific? Are they substantiated? And are they credible? And I'll submit to you, there is nothing specific. We have a lot of generalities. We don't have anything specific. There is nothing substantiated. There's nothing sitting here showing you today that there's been any impropriety, direct evidence of any impropriety, and none exists. None exists anywhere against Commissioner Richardson that she has in any way acted with any level of impropriety. To the contrary, her actions and her efforts have been wholly transparent, and they are wholly permitted under the 501c statutes that this country has and that this country maintains. This is exactly how elected officials are to go about advocacy following the various regulatory codes and things that were passed under the 501c amendments and the 501c structures. So that's what she's engaged in. And then finally, there is nothing showing that anything she is doing using her position as commissioner, meaning when she's sitting up there on that dais, she is taking a vote that is designed somehow to allow for private gain for her own personal benefit. There's some business matter before the county from which she is deriving some sort of personal or private benefit. So we would ask that the complaint be summarily dismissed, that the commissioner be allowed to go on about her business and get back to representing those who elected her. I'll take any questions if there are.
Okay, I'll invite members of the board to ask any questions that they may have of Mr. Odell.
I do have one question. As it relates to disclosure, was Commissioner Richardson required by law to disclose or register her nonprofit organization? Was she required by law as the commissioner or as a commissioner to disclose her nonprofit organization?
Let me parse the question, and I don't mean to quibble with you, but I want to be
Okay.
clear about the question. Was she required by law to make it public? You mean register it with the secretary?
Make it public. Just based on the complaint, it was stated that she did not disclose her nonprofit organization to the public. So my question to you was, by law, as a commissioner of Cobb County, is she required to disclose her nonprofit?
So I want to, again, this is why I asked you to parse the question for me very carefully. The nonprofit was the 501c entity, which first of all has its own executive director. The 501c entity is properly filed, registered, and disclosed with the state of Georgia. And the constitution and makeup of that entity is properly public. It is properly registered and public, just as every other action committee in the state of Georgia is properly registered and public. So the answer to your question is, to the extent anything was required, it was done. I don't know the assertion that it wasn't.
I'm not for sure if you answered my question or not. I'm just speaking specifically as a commissioner of Cobb County. Is Ms. Richardson required to disclose her nonprofit as an
I guess what I'm
elected
struggling
official?
is in what context? That's what I'm struggling with. In what context?
As a commissioner who has been elected by the public, is she required to state, is it illegal for her not to have shared that she has a nonprofit organization? Was there anything wrong with the fact that, if indeed the allegation is correct that she did not disclose, was there anything done improper?
Again, I'm going to keep coming.
Let me stop you there, Mr. Odell, because I want to be sure that we all understand as a board, we're not here to determine whether some financial disclosure with campaign finance laws were followed. We have to decide whether the Cobb County Code of Ethics was followed. And so if I may, Mr. Odell, do you know if the Cobb County Code of Ethics, and specifically what is alleged in Complaint 1, which is that Section 247 requires disclosure of having created a nonprofit organization?
Yeah. And that's really what I was parsing down
Thank
to.
you.
Are you asking, does anything in your code of ethics require that she says before they take a home rule vote, hey, by the way, I have an organization that's advocating for home rule? No, it doesn't. Because there's nothing within that that involves her pecuniary gain. There's nothing within that that involves her own conflicted financial interest. So in the first instance, I want to be clear, it is disclosed. The public is aware of it. But to the second, the question almost has the cart out in front of the horse. That presupposes that there is some inherent conflict that she would be required to disclose when there's not. It would be.
Okay. For those that are in attendance, you may disagree with what the parties are saying in their presentation, but please hold your comments to yourself and to show the parties the respect, please. Go ahead, Mr. Odell.
And again, that's where I come under 2-46, which is the provision that I cited you. The interest there relates to a for-profit interest. In other words, the disclosure there falls under an interest for profit. So if the county commission was about to condemn a piece of property that Commissioner Richardson owned, now we're in the water, because she has an interest in the outcome of the first example that would come to my head. There may be a better one, but now we have an interest. Or her husband, the county's about to make a grant award to an organization or hire a business to do a road project, and she's not married, so I can't even say her husband. Let's say she was married and her husband's employed we're about to award a bid contract to this agency and my husband's employed there. In that instance, we have a for-profit gain arising from a county vote. And in that instance, that's where it would be triggered. An advocacy interest saying that I'm advocating against this doesn't create the conflict that your code addresses.
So, Mr. Odell, let me ask you the same question that I asked of Ms. Fisher. I suspect that you'll take the position that it isn't, but does it matter the purpose of the organization for determining whether it poses a conflict with a county commissioner's public duty and responsibility?
The broader answer to your question is no. The commissioner is charged to advocate for what they believe in and what they believe they were elected to do. And there may be positions that people disagree with and say, I don't think the commissioner should be out there fighting for that. But that's what they're charged to do. And that's where the whole process gets a little twisted up. That's what we expect them to do. And when they don't advocate and do what we ask them to do, then we have an election and a new body gets to determine who will be their commissioner to go fight and advocate for what they want to fight and advocate for. And that's the charge. Each of the commissioners has various charges that they're fighting for right now, whether it be veterans or pets or whatever. That's their charge, and they use their role as a commissioner to say, this is what people elected me to go do and fight for. And that's what we expect. So the broad answer to your question would be no. Now, I think, and I don't want to get extreme here, obviously, if you were advocating for things that were just, I think, beyond the pale, we may wade into uncharted territory there. But
Or perhaps, against the broad interest of Cobb County.
Yeah, and that's sort of what I'm saying. But then again, the remedy would be the electorate, not the ethics code. I mean, if a commissioner was out there, I guess, with an advocacy organization saying, you know what, we should just annex ourselves to Cherokee. I mean, in the extreme example, I guess, maybe we could come up with a scenario, but certainly not within the confines of advocacy and education. We tolerate advocacy and education that is strictly partisan.
Talk to us about the appearance of impropriety in the For Which It Stands website, soliciting membership dues and offering the perks of access to elected officials and promoting voting power.
Sure. Well, let me take those backward.
Okay.
I think the promoting of voting power is advocacy for the individual's right to vote.
Okay.
Not suggesting, I don't think there's any insinuation or suggestion that by joining this organization, somehow you get an extra vote the next election. I mean, that's
right.
That's not the insinuation or assertion. So the advocation is this is how your rights as a citizen are exercised, and you need to protect those. And I don't think there's anything inherently wrong with that, and I don't think certainly there's an appearance of impropriety there. The broader, when you talk about access, then once again I come to the structures that we have in existence. You can become a member of a variety of 501c organizations, political parties. You can join. They all have membership levels. They all sell you that you can come to a breakfast on Saturday morning and shake hands with, look at all these elected officials that are coming to talk at our breakfast. And if you're a $500 member, you get to sit here. And there's nothing inherently improper or undue about that. That's the system and construct that our country, our county, our state has adopted within the framework of advocacy and organization. And we can quibble about the 501c laws all we want, but those are the structures, and that's precisely what happens. I think the issue would be far greater had it not been transparent. But everything is in accordance with the 501c laws as permitted under our system and is perfectly transparent to the public, as opposed if you had a system maybe that was less transparent, would certainly create far more greater appearance and is open. It's not a system that's blocked from the general public from view or otherwise, that there's some level of something that certain people have that others cannot be part of or aren't invited, so it's absolutely within the system that we have regarding our elected officials.
Thank you. Any other questions? Okay. Thank you, Mr. Odell.
Thank you.
So at this time, we'll move to the discussion phase of this board's meeting. Having heard the complainant, Ms. Fisher, explain the specific allegations of a violation of the Code of Ethics, and heard Mr. Odell's response on behalf of Commissioner Richardson. I'd like to invite all members of the board to freely share their thoughts, concerns, and within the scope of the Code of Ethics and as it relates to the allegations. This isn't the forum for debate over the home rule. The Georgia Legislature, General Assembly, those opinions, quite frankly, don't matter. This is really whether there is sufficient information provided in the complaint that would warrant us as a body going further to hear from witnesses evidence about an alleged ethics violation. Anyone want to start? Okay, I'll start. Okay.
Yeah, for me, the home rule is being dealt with in the courts and in the legislature, and that certainly, in my view, is not in the purview of this group. You know, I don't want, in my view, I don't want that to cloud what we're looking at. And certainly, when I first read the complaints, I said, well, you know, let them sort it out. That's, when I looked at the code of ethics, is that our charge? And I, to myself, I said, no, it's not. And the one thing that I had questions about was really, was there personal financial gain? Is there substantial evidence that shows financial gain? And was there, what does special access mean? If you gave this money, what does special access mean? Today I've heard, well, there's profit in nonprofit corporations, whether or not a nonprofit applies. But for me, this is what I wanted to hear today, the specific evidence that shows that.
I'm going to say this. I mean, I didn't come in here with any preconceived notions. However, I did go over this a million times at my home, and I think the word here for me is optics that I'm going to use. And based on appearance, I'm going to use. All these words were the appearance of being capitalized. You know, optics is everything. We know timing is everything also. So, I mean, we don't have any evidence that that Ms. Richardson has profit, but we don't have evidence that she didn't either.
Well, I guess the evidence that we have is her personal declaration that there wasn't.
Good point.
And that's about it.
To that point, let me suggest something. The County Code of Ethics contemplates a commissioner having other employment. Now, I'm not suggesting that Commissioner Richardson is employed by for which it stands or for any other organization, but the County Code of Ethics, Section 2-50, contemplates the possibility of there being compatible and incompatible employment. So I'm just going to read it. No officer shall engage in or accept employment with or render services for any private business or professional activity when such employment is adverse to and incompatible with the proper discharge of the officer's official duties. In my mind, it doesn't really even matter whether she received some sort of compensation as a member of for which it stands or not.
So you're saying it aligns?
As long as it's not incompatible with her public duty and responsibility, and it's not alleged that her involvement for which it stands is an incompatible employment, and that in and of itself would be an alleged violation of the County Code of Ethics. So I think we can't view things in a vacuum, right? If we look at the whole Code of Ethics, it contemplates that these public officers can have private interests and private employment and personal interests and advocacy interests. But as long as it's not incompatible with their public duty and their public responsibilities and their official acts, then it's permitted. Ms. Pendle, Ms. Wheeler, any thoughts?
Yes, I have to say that I agree wholeheartedly with what you just said. But more importantly than that, we, again, did not see any specific evidence or information that anything against our ethics code has occurred. Literally nothing. Today was definitely the day to do that. Today was the opportunity. It did not happen.
Ms. Pendle, any thoughts?
I do. As it relates to Cobb Ethics Code, Section 246B, one of the things that stood out for me was for-profit organization. This is clearly not a for-profit organization. And then Section 246C, that states it disallows a commissioner for using public office for private gain. And again, I believe that most elected officials are part or participate in nonprofit organizations as it aligns with their duties as a publicly elected official. So again, the for-profit and for private gain. And as you have said, multiple people here on the panel have said, we've not seen any hardcore evidence to support that there was private gain.
Thank you, Ms. Savage. Ms. Pendle?
I was thinking along the lines of Ms. Wheeler's. What I was expecting today was some sort of evidence that would show that financial gain, which is kind of the most important thing that I see here. And I did not see that evidence today, that there was personal financial gain out of the nonprofit business.
Here's some thoughts that I have. I think Mr. Odell has removed the request to dismiss for technical deficiencies. I think that the contents of the complaint certainly allege, with enough specificity to me, and certainly Ms. Fisher's explanation did make clear what she was alleging was a conflict of interest. And what she was alleging was the private gain, the personal benefit to Commissioner Richardson's actions. I agree with Mr. Odell that it can't be viewed that simply doing what you believe your constituents want you to do, and that somehow gaining that sort of political favor out of your voting constituency keeps you in power, keeps you in office, and therefore is a private gain to you that is impermissible under the county ethics. I don't see the ethics code as prohibiting that. That would prohibit every elected official from working in good faith, doing what they believe their constituents want them to do. That would prohibit an elected official from voting on, this zoning application because, this community that I represent believes that I should vote this way in this zoning application. And I certainly want to do what my constituency asks of me to do, and that's going to get me reelected. Somehow that is a conflict of interest, that you are doing what you believe your constituency wants you to do. And she was elected to represent District 2. To the extent that she's advocating to remain as the elected commissioner of her district, that's not a conflict of interest in my mind. But I do think that we should decide on the merits of the complaint. The code requires of this board and of county officers to be impartial and to guard the independent judgment of public officials. This is an independence of judgment shielded from improper influence or personal benefit. It requires that officers, that is county commissioners, to avoid conflicts of interest, and if one arises, to abstain from official acts to avoid the appearance of impropriety. A recusal from official action is only required by the code. It's not required simply because another county officer requests a recusal. A conflict of interest, in my mind, is a situation that poses a risk that an officer's personal or private interest will induce the officer to act in a way that is not in the best interest of the county and her constituents. If anything, here, what I've heard and seen is that the stated interest of the nonprofit, that is to protect local control, and the commissioner's public interest to her constituency are aligned. I don't see a conflict there. She had a duty to continue to represent the constituents who elected her to a 4-year term, which she judged to be best fulfilled by voting for the home rule resolution. I don't believe that Section 247 requires a disclosure orally or written prior to a vote on the home rule resolution. Accordingly, I would not find, and I would encourage members of the board to agree, that there has not been any substantiated evidence in complaint number 1 to support a reasonable belief that the Code of Ethics was violated. Regarding Ms. Fisher's allegations in complaint number 2, that a fiduciary conflict of interest by filing as a registered agent for a nonprofit violated the Code of Ethics. Not only is the allegation not a violation of the Code of Ethics, the nonprofit's mission does not place the commissioner in a position of conflict with her responsibilities and duties as an officer. I believe that the complaint fails to make out a violation of 2-46A. In the extreme hypothetical that Mr. Odell presented, I think that this might be different if the mission for which it stands served to promote the business interest of like a foreign country or some interest against Cobb County. That's not the case. And other than some conclusory statement that the commissioner created a personal conflict as well as a fiduciary conflict of interest, I haven't seen any evidence of it. A fiduciary conflict of interest, the classic example is a financial advisor that is advising a client, but then the fiduciary doesn't tell the client that the investment tool that they're selling, that they're promoting, that they get some sort of commission out of it. That would be a conflict of interest. That fiduciary has a responsibility to the client not to recommend to them to buy the most expensive product if a least expensive product, right, would provide them the investment goals, for example. We don't have that phrase was used in the complaint, a fiduciary conflict. But there hasn't been any evidence presented whatsoever to suggest that Commissioner Richardson's fiduciary responsibility for which it stands was somehow in conflict with some sort of fiduciary responsibility to Cobb County. I haven't seen or heard anything to support that conclusory statement in the complaint. For which it stands is a nonprofit organization, and 2-46B does not prohibit public officers from engaging in advocacy upon civic issues or promoting a nonprofit organization. The Code of Ethics makes clear in 2-42, this is the policy of the Code of Ethics, that public officials should not, except as otherwise provided by law, be denied the opportunity available to all other citizens to acquire and maintain private, economic, and other interests, except where a conflict of interest would necessarily result. The Code of Ethics does not prohibit public officers from gaining private or maintaining private, economic, and other interests. It's only when there's a conflict that necessarily results. The code further seeks to prescribe only such essential restrictions against conflicts of interest as will not impose unnecessary barriers against public service. When viewing the allegations and the commissioner's actions in the context of the code's policy, I don't see this as really any different than if a public officer also served as a senior pastor, where they promoted their church in that capacity, solicited membership and contributions to their church, or an officer's leadership in Rotary or Kiwanis, or promoted participation and contributions to Must Ministries. Those memberships aren't per se conflicts of interests. They can be if the officer's activities conflict with their public duty and responsibility. Theoretically, hypothetically, those may be, but there hasn't been any suggestion, certainly any evidence of that here. Unless there's any further discussion, I would call this board, I would call the question. Does anyone make a motion?
So we'll need a motion, one of these two motions.
Right.
We'll either need a motion that I move that we find specific substantiated evidence from a credible source exists to support a reasonable belief that Commissioner Richardson has violated section whatever of the Cobb County Board of Code of Ethics, so that a formal public hearing shall be set by the chairman and all parties shall be afforded an opportunity to be heard to determine whether clear and convincing evidence shows the code has been violated. That would be one possible motion. The other possible motion would be I move that we find no specific substantiated evidence from a credible source exists to support a reasonable belief that Commissioner Richardson has violated the Cobb County Code of Ethics, and accordingly, Ms. Fisher's complaint is dismissed. So whoever makes the first motion, that'll be what the board will vote upon. If it fails, then there can be further motions.
Well, I will so move that we find that no specific substantiated evidence from a credible source exists to support a reasonable belief that Commissioner Richardson has violated the Cobb County Code of Ethics, and accordingly, Ms. Fisher's complaint is dismissed.
Okay, we have a motion. Do I have a second?
I second.
Okay. We have multiple
Found
seconds.
So I heard Ms. Savage's voice the loudest.
Okay. All right, so we have a second. That calls the question. All in favor of finding no specific substantiated evidence from a credible source and therefore dismissing the complaint, say aye. All in favor? Aye.
Aye.
Any opposed? Okay. That motion is unanimous. Mr. Rainey?
Ms. Fisher, you do have the right under the code to appeal to the Superior Court within 30 days. So that's in the code if you'll refer to that, if you choose to go in that direction.
I want to thank the presentation from both parties. I do want to certainly acknowledge the value and importance of oversight. I'm certainly not encouraging the filing of ethics complaints. My hope is that we don't ever have to have any. But I certainly appreciate Ms. Fisher, her presentation, Mr. Odell, your response and presentation as well. And I think it is, to have civic engagement is valuable, and it is important that we have a forum where we can provide people the opportunity to be heard and to weigh those considerations against what has been passed as our code of ethics. So with that, I would entertain a motion to adjourn.
May I ask a question, sir?
So we don't,
I've never been to one of
I understand.
I've never been to one of these
Yes, ma'am.
meetings, and I have a
So I'd be happy to entertain your question at the end of the meeting so that we don't actually have an opportunity for public comment. That's not what this board is allowed to do. Okay? Okay, Mr. Yonker, did you move to adjourn? Okay.
Second.
We have a second from Ms. Penda. All in favor of motion to adjourn, say aye. Aye. Okay. So at this time, we will adjourn until our next meeting of the County Code, or Board of Ethics.
I will be in touch soon.
Okay, we don't have one scheduled yet, okay? So stand by. Thank you.
you.